Good morning. My name is Maria Suber.
You need to wait a second here. Yeah. You need to wait for the council.
Oh, I'm sorry.
If you just hold, okay?
Yes.
Just a second.
That's okay. I have reserved 5 minutes for rebuttal. May it please the court, my name is Ines Suber, Maria Suber. I represent Kishon Birch in this case. The issue in this case is very simple. Mr. Birch appears before this court convicted of a crime on a theory that was not charged in the information. In this case, the state specifically charged Mr. Birch with having violated Section 790.23 because he actually possessed a firearm after being a convicted felon. The actually possess a firearm is very important here because of the long set of case law here that says that if the state chooses to charge a person with a specific crime, that state is bound to prove that specific offense as charged in the information.
Counsel, I'm sorry to interrupt you. Before
Yes.
you get too far into the merits, could you tell us precisely what the conflict is as far as our jurisdiction, which case
Yes,
the case under review conflicts with, and
Yeah.
on what question of law?
In Florida, when an offense can be proven in various ways, it can be proven, it had to be proven by the way that the state charges. And we are talking about Lewis, Long, Booker, and those cases that say that if you charge specifically a crime with a specific conduct, the state is bound to prove that specific conduct and nothing else.
Aren't those cases that, well, at least in the case of Long, that's a case where the statute itself listed alternative possible elements and the state chose one and the proof showed the other. In this case, possession is possession, right, statutorily.
Well, in this case,
The statute doesn't distinguish between actual and constructive, is that right?
in this case, the state chose to prove to charge actual possession. It's very clear from the information.
His question was, does the statute on felon in possession distinguish between constructive possession and actual possession?
No. The statute does not distinguish. If the state will have, I had to admit that if the state would have chosen here to charge Mr. Birch with possession of a firearm by a convicted felon, there's two ways. The line of cases that said that possession can be proven both by actual and constructive possession come into play. Just like on a first-degree murder, you don't have to prove premeditation, and you don't have to prove felony murder. The same way with possession. However, that's not to say that that's what controls here, because in this case, the state chose to charge actual possession of a firearm by a convicted felon. And because the state chose to charge actual possession with a firearm, then is bound to prove that he actually possessed the firearm, having been convicted of a felony. And the problem that we have here also is because the jury specifically found that he was not in possession of a firearm during the commission of the offense. So in essence, what we're saying is that if he didn't actually possess the firearm during the commission of the offense, he could not actually possess the firearm in this particular case because the actual possession was actually the element of the crime.
Let me ask you this. Do any of the conflict cases you rely on deal with felon in possession?
Yeah, one of the cases that is in conflict, the name is Jones, and it's actually it's a case out of the First District Court of Appeal.
Jones?
Jones. In Jones, the case was he was charged with possession of a firearm by a convicted felon, but the state proved that he owned the firearm, but he didn't prove that he possessed the firearm at the time of the offense. But they only proved that he possessed it, but he didn't own the gun.
Did you say that this is a first district case?
Yes.
Okay, so that doesn't help you for conflict.
Well, it does help. It does help because for
no,
conflict.
It's intra. We're reviewing the first district.
Well,
right?
It's not, the Lewis is not for possession of a firearm by a convicted felon, but the rationale of Lewis
Well,
applies in
let
this
me go
case.
back to my question.
Okay.
I'm trying to, there's a distinction here between cases in which the statute sets out different ways a particular category of offense can be approved, and the possession statute, which does not do that. And so what I was trying to figure out, if you have any conflict cases that fall in this category of the possession statute where it's not set out in the statute, and it seems like the best you can come up with is a case from the first, which does not create conflict.
Well, Your Honor, I think Lewis might be the one, and Lewis.
What district is that from?
It's from the Supreme Court, but it's not possession of a firearm by a convicted felon. But the theory, the same rationale applies, because what happened in that case is it was aggravated battery that can be proven by great bodily harm or by having possessed
But that's
a
set
deadly
out in the
weapon.
statute. There's a different way set out in the statute, right?
That's the same here with the possession. And the possession is charged with care, possession, possession is ownership, care, custody, or possession of a firearm by a convicted felon.
But the statute does not distinguish between constructive possession and actual possession.
No, the statute does not distinguish that, but the state distinguishes it in this case because it charged actual possession. It's what I'm arguing. It was that once the state chose the words actual, which qualified the possession, it actually modified the possession, it actually charged with actual possession of a firearm by a convicted felon. And because they didn't prove actual possession, and because he starts convicted of a crime for which the theory of which was not charged in the information, that's fundamental error because that's a violation of due process. He stays here in this court charged with constructive possession of a firearm by a convicted felon when that theory was never charged in the information. It's what I'm arguing. And that's the second issue. The second issue is that the trial court incorrectly instructed the jury on constructive possession of a firearm because it was broader than what the charge was. The first district found that the word actual, that we have to look at that way actual, and the actual applies to section 775.87, which is the language which the state must charge if they allege that a person had in the possession of a firearm during the conviction of a felony. That the reason why the state used the actual word actual was to charge that he was in possession of a firearm by a convicted felon. But however, we disagree because you can only look at the information here. On count 2 of the information, the state properly charged Mr. Birch having committed second-degree murder, of which he was acquitted, and it charged that during the commission of the felony, he was in actual possession of the firearm. So the issue here is whether or not the word actual should be construed to apply and to limit the state. It was error for the trial court to instruct the jury on constructive possession because the jury found him guilty of constructive possession, and it was error because he starts convicted of constructive possession when the evidence doesn't even prove constructive possession. We have a situation where there was a struggle. We have direct eyewitnesses that said that Mr. Birch did not have the firearm. We have 2 eyewitnesses that said he didn't possess the firearm. He left the house without possessing the firearm. He immediately turned himself into the law enforcement. We had evidence that he still had blood in his hands. There was no, if he had taken the gun and put it in his pocket, there would have been transferred blood in the pocket, just as they found transferred blood on the rest of his clothing. But there was no evidence whatsoever that he possessed the firearm. There is direct evidence that he didn't possess the firearm, so the we don't even have evidence that he constructively possessed the firearm in this case. But unless the court has other issues, those are my issues. Thank you.
May it please the court. Quentin Humphrey on behalf of the state of Florida. Conflict jurisdiction simply does not exist in this case. The statute itself for possession of firearm by a convicted felon says that that it's unlawful for any person to own or have in his or her possession any firearm if that person has been convicted of a felony in the courts of this state. The key element here is possession, and we proved possession in this case. It is not the word actual, the word constructive. Those are manners in which you can do possession. But that's not the element itself. In order to have conflict jurisdiction, you have to have a conflict within another court or with a prior Florida Supreme Court case. And in the cases the defendant cites, for Lewis, Long, and Booker, the state failed explicitly to prove an element of the case. In one case, the state would allege that he burglarized a smokehouse and proved that he burglarized a hen house. Another one, that the state alleged that he lied to a county solicitor when it turned out that the only evidence they proved was that he lied in a circuit court. The fact remains, we proved the elements of this case, and if you want to grant conflict jurisdiction in this case, which you shouldn't, you have to find a way to show that we didn't prove an element. Regardless, the facts that occurred in this case are unique.
I mean, you will admit that there's broad language in the conflict, some of the conflict cases that that would seem to cover the situation here about the way and I don't have the case in front of me, but the way the circumstance where an offense can be committed in different ways, that in a different sense, that this offense of possession is committed in different ways. It's either actual or constructive.
Well, I think the case you're referring to, which wasn't cited for conflict, was where the state alleged that aggravated assault with a deadly weapon. The jury was given instructions for both deadly weapon and great bodily harm, and the jury checkmarked the box for great bodily harm. That is an actual alternative way to convict in the statute itself, and the jury picked the one the state didn't allege.
I understand that, but there's broad language in there that seems that could be interpreted more broadly as the basis for the decision that was reached in that case.
I disagree, Your Honor. The fact remains that...
Were we talking about Brown?
Yes, thank you.
Okay. So in Brown it says where an offense may be committed in various ways, which is true here, correct? Possession can be committed. We instruct the jury. Someone can possess an item by actually possessing it or by constructively possessing it. So you could say that that's an offense that can be committed in various ways.
Well, the difference is that in Brown, those were statutory alternative elements listed.
I understand that, but
here
Justice Kennedy's...
actual and constructive, those are just manners. They're not elements themselves. They are manners used to give to the jury to assist in finding an element.
But I think Justice Kennedy's point was that the way that it's described, by talking about an offense that can be committed in various ways, rather than talking more specifically about when a statute sets forth various ways, that broad language would seem to apply to the facts of this case.
I disagree, Your Honor, still.
So you're saying this is not an offense that may be committed in various ways? Possession is not?
I'm saying that possession is possession, and the manner in which possession is committed is definitions or methods given to a jury to help assist them in making a determination.
But those are the same? Actual and constructive are the same ways?
They are different manners.
They're different ways.
They're different manners in which you can commit an offense, but the actual and constructive are not elements in themselves. The statute is clear. The element is possession.
Well, I think your point would be that the holding of the case has to be understood in the context of the statute they were talking about.
Yes.
And that the language is not as broad as it appears when you read it in the context of the opinion.
Yes, Your Honor. And just to highlight as an aside, Jones v. State, raised by the defense, was a first DCA case, and you can't find conflict jurisdiction from a decision from the same court that's up on
I
appeal.
think we've got that.
So regardless, either way, this case.
Let me ask you this. In Brown, part of the line of reasoning was that the state had actually charged the subsection for one of the methods, and I think, if I remember correctly, it was the aggravated battery, use of a deadly weapon.
Yes, Your Honor.
So that subsection was charged, and it specified in the information committed aggravated battery. And then in reasoning, they said that because they did not charge the other section, subsection, which is use of great bodily harm or resulting in great bodily harm, and didn't specify it, that they sort of reasoned away consistent with your argument, correct?
Yes, Your Honor.
Is there another conflict case where, or alleged conflict case from a different district, where the information actually alleged the entire statute, so that an argument could have been that it was alleged, like here, that the whole statute was alleged, but they found that because there was a word that was limiting in the information, that resulted in a different.
Which case are you specifically?
I'm asking if there is one.
I'm sorry. I'm not aware of it
Yeah, okay.
myself. The fact remains, though, that this is a very unique factual situation that isn't necessarily a great case to build case law off of. Let's look at what happened here. When you look at the information, we have a case from late 2013 from the First DCA called Arnevi State, that's 128-7, 2nd 87, that says if you want a 10, 20 life sentence in the First District Court of Appeal, you have to put the word actual possession in your charging document. Before that point, you can just use the word carries and cite to the statute of 10, 20 life, and that was enough. First DCA said you have to put the word actual in there. Then the defendant at trial didn't object to the jury instructions with constructive language, and which makes sense because if he was found in non-actual possession as the specific fact finding, he doesn't get a minimum mandatory sentence. It's to his benefit to go along with the language that was included in for constructive possession. And then we get a jury question about the specific factual finding that the court says, go back, rewrite it, and give it to us again. And the jury doesn't do so. Instead, they come back with a verdict, and they rewrite the question, don't give it to the judge. And so it's not answered. And then we have a defendant who goes through a motion for a new trial, doesn't raise the issue, until an appellate attorney comes along and says, wait a moment, I don't like what happened here. We have a unique factual situation that just doesn't work. Now, what the better policy that this court should adopt is to overturn Arnett, or not overturn, sorry, disapprove of Arnett. The fact remains that what the state was forced to do because of Arnett.
But you don't want us to do that in this case.
No, if you find conflict jurisdiction. I don't believe conflict jurisdiction existed, but if you are going to find it existed, the policy this court should do is disapprove Arnett. The state was required to put a sentencing requirement in their charging language, which makes no sense. And we wound up in this situation.
Oh, but that's an Apprendi thing, right?
Well,
So what would be the correct way? I'm not disputing that.
the proper,
so
what
what's
this
the correct
court
way to handle
should
that?
say is disapprove Arnett and say that the state cite to 1020 life in their charging document, 77508 subsection whatever, and file a notice just like we do with prison releasee reoffenders or with habitual violent felony offenders, and say that we are seeking, because we're filing this charge, we are seeking an enhanced sentence because he actually possessed a firearm. What you do is you get your sentencing language.
You get the jury finding how, though? How, just mechanically?
Well, what you file a notice, and then you still do the interrogatory of a specified jury finding in the verdict form, whether you put it as a separate thing or you put it as a subsection to the question. Either way, that isn't relevant. You still make the jury finding, but you give the defendant notice of what he's looking at. You don't put sentencing language where it doesn't belong, which is in the charging document.
So you're saying that the word actual possession doesn't need to be in the charging document to preserve the 10-20 life sentence.
Correct. It absolutely doesn't need to. The whole point is to give the defendant notice that we're seeking an enhanced sentence. There is no reason to put sentencing language in your charging document, cite to the statute, but there's no reason to. And then if you give them the proper notice, you say we're seeking this, and because of this, and the defendant's put on notice that, hey, they're seeking a higher sentence against my client, and they can go from there. And the jury then makes their proper factual finding as part of the verdict form. That is a better policy for this court to adopt if they choose to accept conflict jurisdiction in this case. Regardless, we have proven possession in this case anyways, because the defense referenced that we've not. Let's look at the facts here. There's a 5 and 7-year-old who watched the defendant fighting with the victim in the kitchen. The defendant slinging her against the wall, against the floor, against the stove. He pushed her against the stove. Something happens. Blood starts pouring out of her. She's on the floor. The defendant, with blood on his hands, the children say he runs out of the apartment. The maintenance supervisor sees him run out of the apartment and go to another apartment. The maintenance supervisor goes inside, sees 3 children standing outside the kitchen, crying. They point at their mom laying on the floor, bleeding out. He pulls them outside and makes sure no one else enters the apartment until law enforcement arrives. The medical examiner at trial testified that the victim died of a gunshot wound to the mouth, and no firearm was found in the apartment. Firearms don't have legs, Your Honor. They cannot walk off on their own. The only person that could have removed that firearm was the petitioner. He's the only, it is, and however he disposed of it, I don't know. That's not an issue here, but he removed the firearm. That gives him possession of the firearm. What the defendant is arguing, essentially, is a factually inconsistent verdict. She has not said those words, but that's what she's arguing here. And what she's doing is achieving that by conflating a sentencing requirement that is required by Arnett with a claim that because he was not found guilty of that, they did not make a factual determination of actual possession, but they found him not actually possessing, that equates to an overall acquittal, even though he received a boon from the fact that he did not get a 10-20 life sentencing.
It is a bit incoherent.
Well, you can have factually inconsistent sentences in the state of Florida. That is well-settled case law. The issue is the only issue is if you have a legally inconsistent one. Now, the jury, and when you look at the verdict form, there's any number of reasons why. The jury was clearly confused about the factual determination in this case. So they were asked essentially, what does during the commission the offense mean? That was their question. That was within the revised course that never got answered for them. And when you look at the verdict form and you look at you see that you have count 1, which they acquitted on. You look at count 2, you say possession of firearm as charged, and then right below it, and these are not lawyers, please keep this in mind. We all understand that it's all because of Apprendi, Blakely, and Alani and their progeny. But then they see what they're actually possessed during the commission of the offense. Now, they're going to look at this and say, are they being convicted? Are they asking me to make a second determination of the same thing we literally just decided in count 2? Or is during the commission of this offense relating to the count 1 which we acquitted for? There is no other offense. And so you can find that is one possible theory of this. The second one is a jury pardon, which is a well-recognized standard within the state of Florida. Or they can just have decided that he constructively possessed the firearm because he was alone in the kitchen and he exercised dominion or control of it. We don't know, but the fact remains that this is not a case where the state failed to prove an element of the facts for possession of firearm by a convicted felon. And so therefore, if there are no further questions, the state would ask this court to deny conflict jurisdiction in this case, or if this court is going to grant conflict jurisdiction, to disapprove Arnett. Thank you very much.
For the court not to find conflict jurisdiction, it will have to overrule Lewis, it will have to overrule Booker, it will have to overrule Long, and if more specifically, it will have to overrule Jameis, the state. In Jameis was a case from this court that it was charged with aggravated battery, but with a deadly weapon, and the jury found him with great bodily harm. In that case, the court very specifically said when the statute has different ways in which to charge the information, the state is bound by the way that the state charges the information.
Would you say if the statute has
If
different
the statute
well,
in this
here,
case.
the possession statute, the possession statute doesn't itself incorporate different ways. That's
The
a separate
possession-
matter.
The possession statute incorporates different ways. It can be, if I own a firearm, if I am a convicted felon, I'm guilty of it. If I control the firearm, I'm guilty of it. If I possess it, I'm guilty of it.
But this distinction between possession, the constructive and actual possession, that's not in the statute.
No, it's not in the statute, but the
Consider
state
that.
chose here, just like they chose in the other cases to say smokehouse instead of a structure in the cases. So for the court not to find conflict jurisdiction, it will have to overrule Lewis, Booker, Jameis, Long, Reed, and all the long-standing cases from all the district courts that says that the state is bound by how they charge in the information, and just overruled that and said we don't have conflict jurisdiction. On the other hand, the court can find that jurisdiction applies in this case and find that the state, by choosing actual possession, it chose to charge him with actual possession of a firearm, which in this case it didn't prove. It didn't prove, number one, because the jury found him not guilty of actual possession of a firearm by a convicted felon. The best practice, they asked the state what the best practice is. I don't think Arnett should be overruled. Arnett is correct. I think the best practice is for the state to charge that the person is in possession of a firearm by a convicted felon, and having been in actual possession during the commission of the felony, he was in actual possession of the firearm, or he discharged the firearm. That is the correct way, because that's what the statute says. Thank you.
All right, well, we thank you both for your arguments today. The court will now stand in recess for about 10 minutes.
All right.